Hey everybody, Brett Thompson, Thompson Law Group World Headquarters. It is Tuesday, so you probably know what that means. It's another installment of our Teaching Tuesday. Wanted to make you aware of a statute in Virginia pertaining to transfer on death deeds. So ever since 2013, an owner of real estate is able to record what's called a transfer on death deed. And that will, in some sense, bypass estate administration. So I've got other videos pertaining to whether a person dies with a will or without a will. If you own real estate and you die with a will or without a will and you do not have a transfer on death deed, some administration is going to have to be done, meaning that if there's no will, somebody's going to have to appear, perhaps qualify as an administrator, file a list of heirs. If there is a will, somebody's going to have to appear and qualify as the executor of estate, perhaps file an inventory and accounting. So it can be a little burdensome. It can be a pain in the butt, if you will. So ever since 2013, Virginia has allowed a transfer on death deed. So an individual or individuals that own real estate in Virginia, they can put to record now a transfer on death deed. There are certain statutory requirements for the language in that deed, but essentially you are conveying the real estate upon your death to the beneficiary. So if you're my friend and I want to leave you my house, I can record today a transfer on death deed. And upon my death, by operation of law, you will own the property. So if I get hit by a bus next week, and prior to that happening, I recorded my transfer on death deed, you, my friend, would own my house as operation of law without any further requirements or any further estate administration. So it kind of eases, or it's another avenue to transfer real estate that's a little easier, if you will, than going through the probate clerk and doing estate administration. There are some statutory requirements that have to be fulfilled. Also, if next week we have a falling out and you're no longer my friend, fear not. I can record a revocation of the transfer on death deed. So a transfer on death deed during the life of the transferor can be revoked. It can be revoked by me recording, for example, a deed to someone else, acknowledging that I have a prior transfer on death deed and expressly revoking it. Or I can record a subsequent transfer on death deed. So the last deed in time wins. So if I, for example, record today a transfer on death deed, transferring you the property at my death, but then, a week from now, I record another transfer on death deed, transferring the property to someone else, that second transfer on death deed will trump. And then the third way is just an instrument that expressly revokes the transfer on death deed. So there's some statutory requirements. Good thing is also it's tax exempt, so there is no transfer taxes or recording taxes when you put this transfer on death deed to record. Also, if you want it to be a surprise, there are no notice requirements. So if I'm leaving you my house via my transfer on death deed, I don't have to tell you about it. You're going to find out about it after my death, I suppose. But that, in a nutshell, is how the transfer on death deed works. Also, P.S., more than one party. So if myself and my wife, for example, jointly owned as joint tenants a certain piece of property, we could both execute a transfer on death deed to you, and then the last man standing, if you will. So if I died first and then my wife died after her death, then the transfer on death deed would be effective, transferring the property to you. Any questions whatsoever, give us a call. But that, my friend, is a summary of a transfer on death deed in Virginia. Thanks.